Chapter 5, Civil Rights. The term civil rights refers to the rights of all Americans to equal treatment under the law, as provided by the 14th Amendment to the Constitution. Although the terms civil rights and civil liberties are sometimes used interchangeably, there is a difference between the two. Civil liberties are the basic limitations on government. They specify what the government cannot do. Civil rights, on the other hand, specify what the government must do to ensure equal protection and freedom from discrimination. The Supreme Court has ruled that classification by race and ethnic background is inherently suspect and must therefore meet a strict scrutiny test. Classification based on race and ethnic background must be justified by a compelling public interest. This is a portrait of Dred Scott, an American slave who was born in Virginia and who later moved with his owner to Illinois, where slavery was illegal. He was a nominal plaintiff in a test case that sought to obtain his freedom on the grounds that he lived in a free state of Illinois. Although the Supreme Court ruled against him, he was soon liberated and became a hotel porter in St. Louis. In the Dred Scott versus Sanford case in 1857, the Supreme Court ruled that black people were not citizens of the U.S. and therefore could not petition the court. The Dred Scott decision established the principle that national legislation could not limit the spread of slavery into the new territories. Ending servitude. With the passage of the Civil War amendments, slavery and some of the problems slavery had created were abolished. The 13th Amendment, 1865, prohibits slavery within the United States. The 14th Amendment, 1868, established that all persons born in the U.S. are citizens and no state shall deprive citizens of their rights under the Constitution. The 15th Amendment, passed in 1870, established the right of citizens to vote. Early civil rights legislation. The Civil Rights Act of 1865 to 1875. After passing the Civil War amendments, Congress enacted the Civil Rights Act of 1865 to 75, which were aimed at southern states. These laws attempted to prevent the states from passing laws that would circumvent the amendments, the 13th, the 14th, and the 15th Amendment. We have Plessy versus Ferguson, separate but equal. The Supreme Court went in further in the direction in 1892 in the case of Plessy versus Ferguson, where the court held that separate but equal treatment of people of different races by state government was not a violation of the 14th Amendment. As established with the Plessy versus Ferguson case, this is an example of something that was legal. Separate but equal. They both had an equal opportunity to drink from water. However, it's probably not actually equal. The Plessy versus Ferguson was eventually overturned in the Supreme Court case of 1954. The case was Brown versus the Board of Education of Topeka. The separate but equal doctrine was reversed on the basis that it violates the Equal Protection Clause. So that Plessy versus Ferguson was overturned by the Brown versus Board of Education of Topeka on the basis that it violates the Equal Protection Clause. States that mandated segregation were outraged at interference in state issues by the national government. Serious riots against desegregation took place in a number of different locations. De facto segregation. Racial segregation that occurs because of past social and economic conditions and residential racial patterns. De jure segregation. Racial segregation that occurs because of laws or administrative decisions by public agencies. We have court-ordered busing, a solution to both forms of segregation. It involves housing black students to predominantly white schools and vice versa. It was very unpopular, as you can imagine, among whites and not very popular among African Americans, as you can imagine. It is not common today. By the 1990s, the court was willing in most cases to say that the local schools had done enough to desegregate and no further actions were necessary, despite the continued existence of de facto segregation. The resurgence of minority schools. Schools around the country are becoming segregated again, in large part because of de facto segregation. The attempt to integrate schools has largely failed to improve educational resources and achievement for minority children. The goal of racially balanced schools is giving way to the goal of better education for children, even if that means educating them in schools in which students are the same race. Although the civil rights movement included thousands of leaders, the most famous leader was the Reverend Dr. Martin Luther King Jr. One of the major reasons why King was so successful was his philosophy of nonviolent civil disobedience and nonviolent public refusal to obey allegedly unjust laws. Another approach was Black Power. Leaders such as Malcolm X advocated a more forceful approach than King. His followers also resisted the impulse to culturally assimilate. The Civil Rights Act in 1964. This ended the Jim Crow segregation by making racial discrimination illegal in hotels, motels, restaurants, and other places of public accommodation. It prohibited discrimination in employment on the basis of race, color, national origin, religion, or gender. It created the Equal Employment Opportunity Commission to monitor and enforce protections against job discrimination. It authorized the Department of Justice to initiate lawsuits to desegregate public facilities and schools. Prohibited discrimination in employment on grounds of race, color, national origin, religion, or gender. All these things sound great, right? But in 1964, this was a very difficult act to get through the Senate. You won't need to know any of these for your test, but when they're talking about the Jim Crow laws, here are some examples of them. Voting barriers. The 15th Amendment attempted to establish voting rights for all citizens, except females and some Native Americans. However, some state governments enacted laws that circumvented the right to vote. The effect of these laws virtually prohibited African American males from voting in many of the southern states. The first one, white primaries. Democratic Party began treating primaries as private affairs and offered white-only voting at the turn of the century. This was overturned by the Supreme Court case Smith versus Allwright in 1944. We have the grandfather clause. This was political parties state that only people that had relatives eligible to vote on January 1st, 1867 could continue to vote. All African Americans did not fit this criteria. We have the poll tax. Southern states required payment to be eligible to vote, which eliminated poor African Americans and whites from participating in elections. In the passing of the 1964 24th Amendment, this was prohibited. Yes, 1964, this was prohibited. And then we have the literacy test. The literacy test was created to confuse uneducated voters. Ballots had to be placed in separate boxes in a specific configuration in order to count. Many ballots were subsequently invalidated because of uneducated voters not following the detailed procedures. The Voting Rights Act of 1965. The enactment of the 24th Amendment in 1964, which eliminated any tax for the purpose of voting, was a modern beginning of the end of racial discrimination at the ballot box. The Voting Rights Act of 1965 made state laws restricting political participation by minorities illegal. Women's struggle for equal rights. Activism for women's rights began with the Seneca Falls Convention in 1848. The meeting spanned 2 days and six sessions and included a lecture on law and discussions about the role of women in society. The convention adopted resolutions calling for the elimination of legal, economic, and social discrimination to women. Women's Suffrage Association, the 19th Amendment. Women's rights activists were bitterly disappointed when the 15th Amendment failed to grant women the right to vote. The 19th Amendment, passed in 1920, guaranteed women the right to vote. The struggle would continue until the ratification of the 19th Amendment to the Constitution that states, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex." So the 19th Amendment, passed in 1920, granted women the right to vote. Looking at this chart is the years by country in which women gained the right to vote. Notice United States is ahead of a lot of other countries, but yet Germany and Canada were still ahead of us. Gender-based discrimination in the workplace. Title VII of the Civil Rights Act of 1964. This legislation prohibits gender discrimination in employment. This has been used to protect women from workplace discrimination. In 1978, Title VII was amended to include the condition of pregnancy. Sexual harassment. The Supreme Court also has held that Title VII includes prohibition on sexual harassment. Some problems with addressing sexual harassment complaints are how to define a hostile work environment. The court has attempted to clarify this issue. In the picture on the top, we have President Kennedy in 1963 signing the Equal Pay Act. In the year 2012, women will comprise the majority of the U.S. workforce, yet women, in spite of Title VII and legislation such as the Equal Pay Act, on average continue to earn less than men. It ranges anywhere from 77 cents to 81 cents for every $1 that a man would make on average. This has been an issue even in 2012, as President Obama has addressed this in his State of the Union. Glass ceiling. This term refers to hard to identify but real barriers to the promotion of women into positions of authority. It is often difficult for women to rise to the top of an organization. Age discrimination is potentially the most widespread form of discrimination. The Age Discrimination in the Employment Act of 1967 prohibits discrimination by age in all but a limited number of occupations where age is considered relevant to the job. Also, many individuals do not desire retirement when they reach the age set as the retirement age by a company or government. And mandatory retirement has progressively been made illegal by laws passed in 1978 and 1986. In 1965, President Johnson issued an executive order requiring all contractors and unions doing business with the federal government to take affirmative action into hiring minorities. 2 years later, this order was amended to extend affirmative action to women. Affirmative action describes those policies that give special preference in education, admissions, and employment decisions to groups that have been discriminated against in the past. As originally intended, affirmative action policies were an attempt by the federal government to level the playing field for women and African Americans in particular. Affirmative action remains a controversial issue for several reasons. Some people argue that racial and gender-based discrimination in employment and school admission decisions is now so infrequent that affirmative action is no longer warranted. Others argue that the backlash created hurts race relations. Some women and African Americans argue that the presence of affirmative action diminishes and undermines their achievements. On the other side of the argument are the economic realities. There's no doubt that women and African Americans lack economic parity in the U.S. Affirmative action represents one attempt to remedy this. Popular support of affirmative action programs seems to be based somewhat on racial identity, with majorities of African Americans and Hispanics supportive of affirmative action, and whites widely divided on the issue. Regents of the University of California versus Bakke. The medical school of the University of Cal at Davis in 1971 increased the size of its classroom from 50 to 100 students. The first class had no minorities. To address the absence of minority students, the Regents created a special plan in which 16 of the 100 spaces were set aside for minority applicants. These candidates for the 16 slots do not have to meet the same academic standards as the other applicants. Alan Bakke was a 37-year-old white NASA engineer, applied with test scores higher than those 16 minorities, but he wasn't accepted. The Supreme Court ruled that medical school's strict quota system denied Bakke the equal protection guaranteed by the 14th Amendment. The court ordered that the med school to admit Bakke as a student. The court also ruled that both the Constitution and the 1964 Civil Rights Act do not allow race to be used for one factor among others in competition for available places. Adarand Constructors versus Pena. Further limits on affirmative action. In Adarand Constructors Incorporation versus Pena, the U.S. Supreme Court ruled that when government use affirmative action programs, they must do so under strict scrutiny rule. This means that governments typically cannot use the quota system, and once a program has been deemed successful, it must be eliminated. In two cases, in 2003 involving the admission policies of the University of Michigan, the court indicated that diversity was a legitimate goal in college admissions, but could not be achieved by automatically assigning points to minority applicants. In the Adarand construction, Adarand took out a bid on a DIA project and was awarded the bid. However, he was a white owner company, and this money was set aside for a minority contractor. Adarand sued because he was the lowest bidder, and the Supreme Court ruled in a 5-4 for the Adarand constructors. Gratz versus Bollinger. Gratz was a white student and wanted into the University of Michigan. 20 points were automatically assigned out of 100 if you were an applicant from a minority group, an underrepresented minority group. How did the Supreme Court rule on this case? We'll get to that in a second. Grutter versus Bollinger. At the University of Michigan School of Law, Grutter was a white student and he wanted into the University of Michigan. The applications were evaluated based on all information available in their files, and race was one of the factors. How did the Supreme Court rule on this? We'll get to that in a second. Gratz won because the undergraduate admission program was not narrowly tailored. Grutter lost because the court found that racial diversity is a compelling state interest and the program was narrowly tailored. Parents involved in Community Schools for Seattle School District Number 1, 2007. Seattle allowed students to apply to any high school in the district. In Seattle, there are over 12 high schools alone. The second most important tiebreaker on the application was race, the first being your location to the school. The Seattle School District decision, the court applied strict scrutiny to this case. And they said the only way to stop discrimination is to stop discriminating on the basis of race. And the district failed to show its goals could not be met with non-race conscious means, and it was not allowed to continue this practice.